Alice here with part 12 of Corazon, the My Docket series on Corazon real estate. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. This video goes into the filing of my motion to amend the complaint. I don't remember why I did this, and so I really don't have much of a mindset portion to give you. I'm going to end up learning why I did it when I actually go through the document. I do want to mention that the rules of civil procedure do allow you to amend your complaint in the face of a motion to dismiss if you do need to include certain allegations and for whatever reason those weren't included, and of course you can prove it. Then you can ask the court to amend the complaint, and typically the court's refusal to do so constitutes an abuse of discretion and reversible error. There are some exceptions though. For example, if the amended complaint would still not survive a motion to dismiss, then they call that futility. You're trying to amendment of the complaint would be futile, and if that's the case, then they will still allow a dismissal to occur. But in any event, I think we really do need to jump into what I have filed. Okay, we have here my motion to amend the complaint. Standard introductory paragraph indicating this document was filed by me, appearing in proper person, which means I don't have an attorney. And let's move on. Factual background again. On September 20th, I filed a complaint in the instant case, together with a notice of extension of time. On October 12th, they filed an answer and counterclaim. On November 16th, they mailed the move-out security deposit accounting to me. Okay, now it makes, okay, so the move-out security deposit accounting would indicate to me that they're retaining monies they shouldn't be retaining, and so I'm going to add some allegations to the complaint to recover those monies. That's what that looks like. Argument. Rule 15 sub A. A party can amend the pleading as a matter of course any time before a responsive pleading is served, or otherwise a party may amend the complaint by leave of the court or written consent to the adverse party. Leave has to be given when justice so desires, and then they talk about this in Adamson v. Bowker. This is an interesting case because it talks about what I talked about earlier in this video. The adoption of the rules of civil procedure, they have emphasized that Rule 15 sub A mandates leave to amend shall be freely given when justice so requires. Rule 15 sub A declares that leave to amend shall be freely given when justice so requires, and that the mandate is to be heeded. Let's see. In the absence of an apparent or declared reason such as undue delay, bad faith, dilatory motive on the part of the movement, repeated failure to cure deficiencies by amendments previously allowed, undue prejudice to the opposing party by virtue of allowance of the amendment, futility of the amendment, that was the one that I mentioned earlier. In the absence of one of those several things, then the leave sought should, as the rules require, be freely given. And I like this last sentence here. Of course, the grant or denial of an opportunity to amend is within the discretion of the district court, but outright refusal to grant the leave without any justifying reason appearing for denial is not an exercise of discretion. It is merely an abuse of that discretion and inconsistent with the spirit of the federal rules. We subscribe completely to this interpretation of the intent and purpose of Rule 15 sub A. Because Corazon sent the security deposit accounting after the complaint was filed, then I was unable at the time to determine whether I had additional cause of action. Now that I have reviewed the security deposit accounting, I find it necessary to add conversion as a cause of action to my complaint. Corazon cannot claim prejudice because I notified it well in advance that amended pleadings would likely be necessary, and even if so, in good faith, to offer them an extension of time. I don't think that's conversion. I think it's probably breach of the contract. Not conversion. I think conversion is a tort. Maybe I'm wrong. See, this is the kind of stuff that would be cool if somebody would comment on. Is conversion a tort? And if so, it's probably not something that I should be bringing up here. Probably just a breach of contract on that part. Let's see. Conclusion. Well, we already know. I'm saying that I want to amend. Declaration of Alexander. So this is me indicating that all the facts alleged in this document are true and correct. Rule 5, certificate of service indicating this was mailed to Corazon Real Estate. List of exhibits. Here's a proposed amended complaint. So I don't know if I did this by instinct or if I actually read the rules. If I remember correctly, I'm 99% sure that the rules of civil procedure require you to provide a draft of the amended complaint when you file a motion to amend the complaint. So I either knew this because of the rules or I just got lucky. Exhibit 1, amended complaint. So it looks like the the italicized portions are the portions that I changed. I guess we'll look through these. Here's something. On July 18th, Corazon sent a letter demanding the aforementioned $25 for a no-show and $105 for repairing the air conditioner and threatened eviction and fines. And then on July 24th, personally served a written notice demanding repair of the toilet. So I'm including these allegations. On October 14th, moved into my new place of residence at this is also an ancient history address. And then we've got October 17th, finalized my move out from the unit by turning house key and mail key in. On October 24th, returned a second mail key and the pool key. And then on November 16th, I received my security deposit accounting alleging $20.74 owed after they took the entire deposit. Some minor language allegations, statutory obligation, attempted eviction, some move-out expenses apparently that I incurred, which I'm not sure I can claim. Maybe for retaliatory eviction you can. Probably, that would make sense to me, but we'll see. So, okay, this is the security deposit that they kept. Conversion of a security deposit. See, I don't know if this is conversion, guys. I have a feeling it's not. I have a feeling it's just a breach of the contract. So these allegations look to be pretty simple. We've got the general cleaning, carpet cleaning, utilities. We've got the eviction fees, late fees, and rent, which they wrongfully charge, which I'm trying to claim. We've got unlawful withholding of security deposit. And then I just added that to the list of requests. And everything else is just unsigned because this is just a draft. Next, we have a notice disputing itemized written accounting. So it looks like I'm disputing. Okay, I see what I'm doing. I'm invoking this law, which allows me to block the landlord and any credit agency they assign it to from reporting this on my credit report. There's no reason why this should be filed into this case. I should have just sent this to them as a letter. So if I could go back in time, I wouldn't file this. It's not going to hurt me, but it's just one extra thing and it looks goofy. It shouldn't be in the case. This is actually a great thing to do, though. I think I have a video on this topic. I really wish I could remember the title of it. Check out my playlist on landlord tenant, and you should find it. This is a wonderful law. I've used it before so many times. There was only one time a credit agency tried to violate the law, and when they did, I sent a communication to Experian, TransUnion, and Equifax, and they struck it from my report. A certificate of service under Rule 5, indicating this document was mailed to the landlord. Well, Corazon Real Estate. Request for arbitration. I don't know if I needed to file a request for arbitration. I think the only thing you need to file is whether you're going to get out of arbitration, like a notice of exemption or something. I don't know. Maybe it was okay to file it. I would have to check the Nevada arbitration rules. This is just required. There's a Nevada arbitration rule, and it says if you're requesting less than $50,000, then you just have to go to arbitration. It's court-annexed arbitration. It's not arbitration like people think with a separate company. It's still connected to the court system in Nevada. Rule 5, certificate of service indicating this document was mailed to the attorney. Rule 7.1, disclosure statement. I don't know why this needed to be filed. Maybe I just forgot to put it in my complaint. That's possibly what it was. It looks like it's a rule that requires you to disclose if you have, I think it's a certain percentage of ownership in a parent corporation or something like that. And they have a similar thing in the rules of appellate procedure. It's called Rule 16.1, I believe. I'm pretty sure that's what this is. Going into the aftermath, I filed 4 documents. They were all free filings, so I incurred $0 in costs. The Corazon Real Estate didn't file anything, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. Corazon Real Estate would eventually have hired their attorney, which is going to review these documents. And I imagine, because again, these are going to be disposed of before the attorneys come on, they're not going to spend a lot of time in reviewing these. So I'm going to say 15 minutes for all 4 documents, which at the rate of $62.50 per hour, which at the rate of $250 comes to $62.50. If you have any questions, feel free to post any questions you have down in the comments below, and I will see you guys next time.